little bit more concise than usual. Today we're talking about SB9, which opens up a whole range of new possibilities for property owners in California. And here to talk to us more about the details of that today is my dad and broker at Franklin West Real Estate, Richard West.
Good morning, Tyler.
Welcome. Good to have you back.
Good to be back.
So tell us about the whys and the wherefores of SB9.
I will, but first I'd like to start off with the 2-minute update. As I mentioned at the first of each one of our podcasts, I'll be just informing the folks as to what's going on in our Northern California area and California, and more specifically Lincoln area, Roseville, Rockland. Anyway, things as I had mentioned 2 weeks ago have not changed much. We've had a decrease in listings of about 3%. That's nothing to be worried about. This is the fall and we're going into the winter months. Typically, fewer people will list their homes for sale in the colder, inclement weather. Actives, we have 3,833 actives, down from 3,950 just a week ago. So we've dropped about 3% there also. Pending sales are up, actually. We've got 1% more pending. So buyers are still out there looking for opportunities to purchase in our Northern California and local counties. We've had an increase of sold properties, 15% in September from the month of August. So that's quite a bit of an increase in sold properties. A lot of those properties just took a little longer to go through the escrow process. Price increases down 11%. People are not increasing their listing prices. They're actually lowering their prices. And then we're down about again, 11% on decreases. And some folks, after the listing, for whatever reason, they feel compelled to increase their price, only about 1.6%. So all in all, with the 2-minute wrap, we are looking at just a small slowdown. As I mentioned, we're going to see that. Part of that is just typical and normal through this time of the year. You'll hear all kinds of speculation out there about the markets crashing, and because of all of the shortages and economic woes and fires and everything else people can dream up as to why they know real estate's going to go up or down. But I like to just stick with the facts and the statistics. And for now, everything looks great for sellers. Unfortunately for our buyers, prices continue to increase. We had about a 15% increase so far this year from last year. And but we're going to start seeing possibly a slowdown in that and become more of a moderate real estate market in the next 6 months to a year. So that's the 2-minute wrap up for today.
Thank you. Thank you. Good information if you live here in the greater Sacramento area, especially if you own property and have been thinking about selling recently. And I think that kind of relates to our topic for today. We have this new law that passed, SB9, and it is broad strokes here, a residential zoning law that applies to the state of California. And when I first heard about this, I thought it was really intriguing. So I wanted to mine all the information from you right then and there, but I decided not to look too closely into it, so you could give us, so you could render the law in greater detail for us and our audience today.
Well, yeah, the day after Newsom was saved from being recalled, he passed a law called the SB9. And there's quite a lengthy, very complicated, detailed zoning changes going on for urban areas. So what I want to do is I'm just going to cover like the 14 most basic changes. Try to say it in a way that makes sense rather than all the complicated zoning speak that the counties use and the state government. Number one, the lots are not for rural lots where you have 5, 10, 15, 20 acres out there and you want to split that into rezone it if it's just zoned for 10 acres to rezone it naturally into two lots, and which would allow you to put two properties per lot. So this is really just for urban areas in the city, in the like Lincoln, like Roseville, like Rockland. If let's just start with number one. And most of the stuff I agree with. Some of it's very questionable. The lot cannot be located in a high fire zone. Of course, that makes a lot of sense. But there's very little urban areas in fire zones in the Northern California area. It cannot be in a historical district; those are protected, or it cannot be a historic home itself. They want to protect these properties. There's so few of them left. And it takes an act of God to do anything with them, to even to remodel. The number two would be lot must be at least 2,400 square feet. Now, for those of you who are not familiar with like acreage, 2,400 square feet is just a postage stamp lot. It's less than a 0.1 tenth. It's like a 0.05 acre. But they're telling us that if you have a 2,400 square foot lot with a home on it in an urban area in a city, then you can actually have that split in two. And in that lot of 1,200 square feet, you can actually put up two properties on each side. That doesn't make much sense mathematically with a 2,400 square foot in my eyes, but that is the rule. 2,400 square feet is minimum. Number three, after splitting the lot that you own and your house is on this lot, each lot must be a minimum of 1,200 square feet or it won't qualify. So divide the 2,400, naturally you get 1,200 minimum square feet or it doesn't qualify. In some cases, there's easements that take up that 2,400 square feet. That's why they put this number three in there. So let's move along to number four. After the split, the lots have to be within a equal split on the lot. In other words, and no larger than 60% on one split and 40% on the other side. No breaking down a 2 acre lot and keeping 1 acre for one house and the other three properties on the other half. So if you got a lot, large enough lot, and you want to split it, and it fits within the guidelines of these 14 rules, you have to split them almost equal, almost 50-50. Number five, you cannot require the demolition or an alteration of housing service. Serving either moderate or low income housing. So if you're in a rent control district, you most likely will not qualify to have your home split down. Number six, you cannot split a lot, which requires demolition or alteration of housing which has a tenant occupying it in the last 3 years. So if you're an investor and you've got a property you've been renting out, or even if you've been renting out rooms and you decide, hey, you know what, there's an opportunity to split my property, rezone it, split it, and then put tenants in there for additional income. That's not going to qualify if you've had any tenants in there in the last 3 years. It's to prevent investors from doing this. They're looking for homeowners to do this in hopes that they might have their folks come live with them, build a granny flat sort of thing, which you could do with what we spoke about a couple of podcasts ago with the ADU, additional dwelling units. But this allows you to actually split your land in half, making two parcels, and allows up to two buildings per parcel, meaning your house, you can build an ADU on it. And after the split, you can build a duplex or two houses on that half. Number seven, the applicant must intend on occupying one of the four units, again, preventing investors from just buying up some single family dwellings, zone, one house per lot, and putting three more units on that property, but not living there. So you have to, if you're going to do this, you must be living in that property when you split the land and also build any additional units. And number 8, the housing cannot be used for short-term rental. In other words, for you Airbnb people, uh, there's going to be a rule of a minimum 30 days of time rentals. That sounds like Airbnb to me, but to the county, it might sound like something else. They want to prevent as much as possible heavy traffic going in and out of our subdivisions and the neighbors to these splittable lots.
And can I just interject there? The if you're intending to uh, build like a accessory dwelling unit for the purposes of renting it out on Airbnb for an income, you can do that within the ADU laws, which we discussed on previous podcasts. We can provide you more information on that, but today we're talking about something that is related but wholly different, which seems to be, and correct me if I'm wrong, encouraging homeowners with some, amount of land to kind of become mini home builders, mini developers, and subdivide that land uh, in accordance with the stack and pack agenda, which I think we're seeing play out here in California.
That's correct, Tyler. Yeah, a little different than the ADU. In an ADU, you actually do not split your land. The ADU and then the junior ADU can be built on there. Junior ADU is a very small little office or very small little apartment, like 150 square feet. An ADU can be up to half the size of the main house. Um, in this case, we're talking about actually splitting your lot in two, where you now will own two APN numbers, which as a benefit, I mean, in a few years, if you decide to sell that one half of what used to be your, let's say, half acre, and you get two split down to 2 1/4 acres, you can actually split that duplex off, sell it off in the future. So that's a little bit different than the ADU, but it's along the same lines. The whole intent for California in their thinking, whether you disagree with it or not, there's pros and cons to both the ADU building and also the land splits. It's law, and folks who qualify in these properties, which by the way is very small percentage of people will have a property that's in an urban area that will qualify and not have any of these rules that would prevent them from having their application accepted. All right, let's go back to the number 9, the new homes that you build. Now, you cannot build those to be your office. It cannot be a commercial real estate office or a retail space. Only a livable abode for one person or a family. So they limit you to residential only. Number 10 rule is any development must conform with the look. Now, this is going to be a fun one, and the feel of the surrounding community homes. And they must conform to the objective zoning and the design standards established by the local city and the county. The cities and counties, of course, as you know, take forever to establish a committee that will be the group that will allow someone to put in a dome house, for example, in the middle of a neighborhood or not. This is saying you cannot do those kinds of things. This is you need to build a building that looks somewhat like other buildings in the local area, local community. Can you imagine if you had a lot, single family dwelling, and your neighbor was accepted for the this program, and they built a dome house or a teepee or anything else that's not conforming?
Yeah.
That would be upsetting to a lot of people. Next rule is local agencies can require the owner to add one parking lot spot for each unit built if it is not within 1/2 mile of a major local transit stop. Meaning, on their analysis of you only need 1,200 square feet, to build two homes on, where would you put your car? I would imagine you'd have to build a home over a one-car garage, because there'd be no space at all, or you'd be parking out on the public street, which neighbors tend to not like.
That sounds like a way to say, okay, you can't share your parking, your driveway with the other unit if you choose to build another unit. You got to provide it with its own driveway, right?
Right. Okay. Number 12, a local public official may only deny you a development application if they find that the proposed project would have an adverse impact on public health and safety or the physical environment, and that there are no feasible and satisfactory mitigation options. Now, I have a college degree. I excel pretty well in English. I have no clue as to exactly what that rule means, but that is one of the rules. They want to make sure that in no way does the new building impact public safety or physical environment, and that there's no feasible or satisfactory ways of getting around those options. So that's a very complicated one. I'm sure it's going to be for the officials as well. Number 13, the original lot, the lot that you have your home on and you think you might want to do this, it cannot have been established through a prior SB9 lot split. In other words, you and your brother own a property and did SB9, and you split the property and you built 3 other properties on it. And you want to take one of those lots, maybe it ends up being a third of an acre or a quarter of an acre if you had a 1 acre lot to start with, and you decide you want to do an SB9 also on that one SB9 quarter lot, they're not going to allow that. And the last one is neither the owner nor anyone acting in concert with the owner previously subdivided an adjacent parcel through SB9 lot split. This is saying that, again, let's use the brothers concept. Brothers buy 2 lots together. They do an SB9 split on one lot, and then they decide on the adjacent lot they want to do an SB9 4-way split or 4-house split. They're not going to be allowed to do that because they were in concert with each other to basically become investors. So that explains what SB9 is. There's a lot of questions people have. I'm getting questions already from folks. We don't have all the answers yet. I talk with county officials regularly, and basically you're going to have to apply and take a look to see if you're going to be able to split your property if it falls into the rulings of SB9. I certainly can come out to your property and be relatively sure that yes, you most likely can be approved for SB9, or there's no way because of various reasons. So with that said, Tyler, I hope that explains what SB9 is.
So if anybody watching this right now has any questions about SB9 and how it may affect their particular situation, feel free to drop a comment in chat and we'll try to address it. Meanwhile, I have a couple of questions based on the really detailed information that you gave us. So you started out by suggesting that this isn't meant so much for like rural areas. So my question is, what's the upper limit on the properties that would fit the criteria for taking advantage of SB9?
The SB9 is designed for single family zoning to take advantage of it. If you already have a large parcel in the middle of a city, obviously you can do things much better than SB9 as an investor, as an owner of the property. You can subdivide that property into low income homes and put 64 apartments on it. You might be qualified to just split it in 4 or build a subdivision in there and put 30 homes on it. or split it in 4, whatever the zoning rules are. But typically, if you've got large parcel in the middle of a city in an urban area, you're not going to need SB9 because that would not be the wisest choice for you to invest. SB9 is designed for the one house owner on a lot that's it's large enough to where they can take advantage of building a second domicile, a second home for a single person, double or a full family. If it's big enough, you can build a 4,000 square foot home right next to your 4,000 square foot home. But it's designed to do a land split so that you can build 2 more properties, which brings up a whole nest of other questions, which we will answer in a different podcast.
And well, on that note, we have Christy, our resident financial and loan guru on the West team here with us, and she may have a few questions regarding the subject. Welcome, Christy.
Hello.
Thanks again for joining us on the West Report. So have you been, I suspect you've been listening in, and
Yes.
You may have some questions related to the financial side and the loans that may be on a property that somebody is hoping qualifies for the SB9 law.
Yes. One thing in my research of this new SB9 ruling is that they don't talk about the existing mortgage that's on the property. And the lender, who's the lien holder, is going to also want to know what's going on with this property because, they have an interest. It's they put up the money, finance the mortgage, so folks could buy their primary residence. And if this is going to change into 2 APNs, 3, 4 APNs, I would imagine that that would cover. They would need to cover all of the APNs because of the existing mortgage. Now, I don't have the answer on that because this is something brand new, but you would think that the lender would want to know
Sure.
that the property is going to be split in 2, 3, or 4. So I will circle back around on the follow-up on this and let our viewers know that once I have the answers.
That would be great. Do you have any comments to add on the SB9 subject, or shall we jump into your market report?
Well, let's go ahead and jump into the market report.
Okay. Thanks for joining us, Dad. That really good detailed information. I'm sure we'll be talking about SB9 again as it becomes clear, like what the parameters are and how people are applying this to their own properties.
Absolutely. And there's pros and cons of the SB9 already coming out. So that's for another discussion. Thanks for viewing, everybody.
Wonderful. Thanks again, and we'll see you next time. All right. The floor is yours.
All right. So the quick market update, and the question I get most asked is, what are rates today? So that's what my market update is going to be on. And the feds are talking about increasing the rates coming up the second quarter of 2022. So that it would be around April. And so with that speculation, the market has already started to adjust a little bit, thinking that that's going to happen. So rates have ticked up slightly. But all in all, the rates are still really good, depending on type of loan, as far as term, 15, 20, 25, 30 year. And of course, FICO score and, equity or how much down. Interest rates are still ranging from the low 2s to the low 3s. So depending on term and whether it's a duplex or a single family home, all these things are a factor. So even though they're speculating that rates will slightly increase come the second quarter, everything still looks good. Things have slowed down a little bit as far as, the purchase still a lot of people that haven't refinanced. It's still a good time to refinance and take advantage of these rates before they do go up. Of course, I don't have a crystal ball, so it's always interesting to see what happens after it happens. But I'm here to keep you all updated, and that is my quick update for current rates.
Wonderful, wonderful. Well, I would love to do another live stream on the SB9 stuff. It may take a few months for us to see how this law actually affects itself on the market before we do that. But overall, I see it as an opportunity for property owners, particularly ones who may want to capitalize on the increased property values in California without having to move necessarily. So if they've got a little bit of extra land, enough to put a secondary domicile on, actually I shouldn't say secondary because they would be subdividing the lot, but distinct from setting up an accessory dwelling unit, which was made easier by California over a year ago. This wouldn't be for like short-term rental. This would be for hypothetically longer-term rental, right?
For the SB9, for like if you're building a second unit, I would imagine that, well, of course, the main unit has to be a primary residence. And so financing, as far as the question that goes on financing, we finance from 1 to 4 units. So that's not a problem. And the other units, as far as financing was concerned, it's completely okay to have a 4-unit property as long as one of the units is a primary. So you can have a 4-unit property and it's okay to rent out the other 3 units.
That's interesting information because it sounds like they did actually put some thought into this law and wrote it so that it fits within the framework, the existing framework of how lenders choose to make loans to residential property owners.
Yeah.
Makes sense.
Yeah, so residential financing is, it's got to fall into that category, especially if you're dealing with government loans, FHA, VA, USDA. Well, it wouldn't count for USDA because USDA is rural. But conventional financing, we do 1 to 4 units. We do residential financing. So, that's what it needs to fall under, not commercial apartment buildings, that type of thing. So 1 to 4 units is what they designed that law around, probably the SB9, to be able to fall within those guidelines. And so I'm looking forward to our next update on this new law, because I will be able to have some more answers for you regarding financing and existing financing, whether you have to refinance and, put different financing. It'll probably be some type of paperwork that needs to be handled through the existing lender. But I will have those questions for you the next time we meet.
Wonderful. We're looking forward to it. Thanks again for joining us for another West Report. We do this once a week, and I want anyone listening right now to know that we're here to answer your questions. So if you have any questions, just leave a comment with your question, and we'll try our best to answer it live on the live stream. See you next week. This is Tyler West and Christy West signing out.